presentation. Okay, so again, just to welcome everybody to the Resident and Family Support Council. Today, our topic is about discharge, understanding your discharge rights and understanding your financial rights. To lead us in that conversation is going to be Teresa. Teresa is going to be starting us off. And Teresa is actually the regional ombudsman for Fulton, Marshall, Peoria, Stark, Tazewell, and Woodford County. So Teresa is going to be starting us today. Teresa, you want to go ahead and begin?
I will. I'm going to have to rely on you folks to tell me if you can see my screen.
We got it.
Yay, I'm so glad. I'm so glad. Okay, so as Lee mentioned, this presentation is about discharges and facility-initiated discharges that you may receive from the administration at the facility. So you've been told to leave the facility, and now what are you going to do? And maybe you have been told. Sometimes when that happens, somebody on staff will say, you need to find someplace else to live. You may also receive a document from somebody in administration with the facility, and maybe they explain to you what the document is, and maybe they don't. There have been instances everywhere in between those two ends of the yardstick that they just hand you the paper and it looks very official. It is an official document. Or they explain to you what it is, and that can be just as surprising to find out that they're initiating a discharge for you. If you are not the resident and you are a representative for a resident, perhaps you receive a certified letter in the mail that is a copy of that same document. That can be very disheartening or unsettling to receive that in the mail, a certified letter that your loved one is going to be discharged from a facility. So that's what we're going to talk about today when you get those types of discharge notices. So here we go. So what you need to know is that many facility-initiated discharges can be actually resolved. And it's important to know that you have rights, you as the resident and the representative have rights that must be followed, even in a facility-initiated discharge. And you need to make sure that you know those rights, and you need to make sure that you know that you become informed and you act on the information that you receive. Remember, knowledge is power. So become informed. That's the first thing that we want to make sure that you know. And there are a lot of protections for you, the resident, that you need to know about in order to know how to navigate this paperwork that you've just received. So these protections are important because discharges violate resident rights. And that violation can be unsafe to the resident, it can be harmful, and it can be obviously very traumatic. So why is it important? It is important because the discharges that violate the resident's rights, as I just said, can be unsafe, harmful, and traumatic. Obviously, I can't dance with my mouse and speak at the same time. They can result in being uprooted from a familiar setting. If you are a resident that's lived in a facility for a long amount of time, for any length of time, you've developed relationships with other residents, you've developed relationships with some of the regular staff, and to leave that environment can be, again, unsettling. And we all know that change is difficult, especially if you are somebody who are older living in a long-term care facility. So in addition to being unsettling and uprooted from a familiar setting, you also are ending those relationships that I just mentioned about, and you have fewer visits from family and friends if the facility that has been chosen to where your current facility chooses to move you to is farther away from where your friends and your family live. So that is also something to worry about that causes stress. And perhaps you're in the hospital. You've gone to the hospital for some treatment, for possibly a surgery or something else that takes you to the hospital, and you've been there for a while, and now the facility is saying, we don't want to take you back. We actually don't have a bed available. In addition to sometimes being in a hospital, the worst case scenario, especially if you've been in a hospital or when they're wanting to evict you, is the fear that you're going to end up homeless. So what you need to know about is 5 facts that you right away when you get this discharge paperwork is 5 facts that you should know about. The first one, obviously, is that all notices of discharging you must be in writing, and they must be easy to understand so that when you're issued, even if they explain it to you, if you don't understand what they're saying, then you tell them, dummy this down for me. Tell me what you're talking about. Why am I being discharged from a place that I've considered my home for a while? And if they've given you that verbal notice, that is not something that is official. They cannot work off of that off-the-cuff comment on how you need to find someplace else to live. So, for example, you're having some issues with the staff and you're telling them how they don't respond well to you wanting them to help you when you hit that call light. You need help transferring from your bed to the wheelchair and the wheelchair to the toilet, and they're not responding. And you've mentioned it many times and you've brought it up often. They know you bring it up often. They know that you need to go to the bathroom often. So they say, you really need to find someplace else to live. Well, that's just not something that can be considered. That is, if you're a representative, maybe you're being told, we can't meet your mother's needs. She's constantly calling our staff off the floor to go help her to the bathroom. That is not a legitimate warning, so to say, of an involuntary discharge. The residents have the right to participate in their own care planning and share concerns about their care. So they're allowed to voice that you need to be more responsive with my call light. A verbal suggestion to find another facility, like the example that I just gave you, is not a discharge. As I said before, those facility-initiated discharges must be issued in writing. So the second thing that you should know right away is that most notices must be given with a 30-day time frame from when they plan on discharging you. So it's 30 days before the discharge date. So if they issue it on July 1st, you have until August 1st to leave that facility. And the facility can't just say that, your mom is going to be in a new facility on Monday and they're telling you that on a Friday. That is an invalid way for them to handle a discharge. And that's when you would want to contact the Ombudsman and or the regulating agency, which is the Illinois Department of Public Health. That cannot happen. That is not valid. So the third thing that you need to know is that you have the right to appeal the discharge. And this slide talks about how you need to appeal that before the discharge date. Well, that makes it sound like before that 30-day on that piece of paper that you get. When in actuality, if you're wanting to appeal the discharge, you really need to get that appeal into either the address or the fax number that's supplied. And you need to issue that or file that within 10 days of the issue date of the discharge. So let's go back to that July 1st to August 1st scenario. July 1st, you as a resident are handed a document that is an involuntary discharge. So you have 10 calendar days, not business days, but you have 10 calendar days to file that appeal. And that appeal is usually, I think it's page 3 or page 4 of the actual involuntary discharge. At the bottom of the page, you merely say that you want to appeal the decision, you sign it, and then you either fax it or send it through the United States Postal Service, which I would suggest send it also certified. But the fax number works as well, and the facility must help you in give you access to their fax machine to fax that appeal in to the office. So that is the third thing that you need to know right away. And that's kind of confusing. And if you need me to go over that again, I'm more than happy to do that. So there are federal laws that provide you with the rights and the protections against this discharge. And if you receive the notice, like I'd said before, then you would contact the Long-Term Care Ombudsman office. You should also know that if this is done legitimately and you receive that notice, that most likely your long-term care ombudsman that's in the area where you reside, your facility, should receive a copy of that involuntary discharge as well. And so we usually in our office, and I believe that it is statewide, I can be corrected if I'm wrong, but when that involuntary discharge is issued, we receive that copy the same day that the resident does. And we make plans to get out and see that resident within 3 days of that involuntary discharge being issued. So now we're going to go to some of the law points that you need to be aware of. There are only 6 reasons why a facility can transfer or discharge a resident against their will, which means facility initiated discharge. The facility cannot meet the resident's needs. I brought this up earlier when I talked about the staff complaining that they're having to put too much attention on one resident over the others. In order for this particular point to be made, the facility really is responsible for documenting quite a bit about how they cannot meet the resident's needs. It can't be just a one and done that they make a notation in the medical record that they aren't able to meet the resident's needs. There has to be some documentation over a period of time to show how they attempted to meet the resident's needs and were unable to do that. The second point is the resident no longer needs the facility services. This can come up when, for instance, if a resident goes into a facility and they're on Medicare and they're recuperating from, they could be recuperating from COVID, they could be recuperating from a surgery, and they need some physical therapy to help them get back on their feet in a more stable way before they can go home. So if they've gone through that therapy and and they've completed the therapy and there are no more allocations, especially for Medicare, once the therapy is completed, that would be a reason why the resident would be asked to leave the facility, because they've completed those services from physical therapy, they're on their feet, they've recuperated, and they're ready to go home. The resident's presence endangers the safety of others in the facility. This could be a situation where possibly there are some stressors that trigger some behaviors by a resident to where they can act out and display some of their anger and kind of project it more towards another resident or staff member. That can, lots of times when that happens, it could be a matter of where there's some physical contact between residents or resident to staff. So that involves, I think, more on the behavior end of it. Again, if there are other instances, I'm going to leave it to the cerebral knowledge of the staff that is also on this call to correct me or to add to my interpretation of that. And the resident's presence endangers the health of others in facilities. And this could be, this could go towards even the epidemic. I don't know if during COVID, if there were instances where facilities tried to do that. It could have to do, the one that comes immediately to mind for me is when it also comes back to some residents who have had, and this is just an anecdotal story, this is not something that it just pigeonholes it into one area, where somebody has a tendency to maybe spit on other residents or have other behaviors that also don't so much endanger the safety of a resident, but would endanger the health of a resident. Again, it could, like I said before, it would involve more behaviors, but I reached to other professionals on this call to help me with the interpretation of that one.
Teresa?
Yes.
What I often see, at least in terms of safety, is sexualized behaviors, and like rarely violent behaviors where they're, occasionally trying to hit people. That's what I see discharges for sometimes.
Yeah, right. Thank you, Stephen. The resident has failed to pay. In this particular box that they would check on the form, it would have to do with somebody who actually is not paying the bill to the facility. And that can be because of a number of reasons. Perhaps they have a power of attorney for their financial who is writing checks directly to the facility, so that if they are on Medicaid or public aid, those are paid, but there are a lot of conditions with Medicaid to where usually your Social Security and or some pensions that you have are paid to the facility, and then Medicaid picks up the back end of that, pays the rest of it. So if you have a financial power of attorney who has stopped making payments on what Social Security and pensions are coming into the bank account, but not paying the facility, that would be an indication that you're not paying your bill. If the resident is their own representative and they write checks directly to the facility, but they've stopped making payments, that is failure to pay. You can't just have Medicaid paying into the facility. You have to pay your share into that as well. Usually when we have involuntary discharges that have to do with this particular point, not paying, those can be resolved. Lots of times there are facilities that are willing to, I won't say bend over backwards, but they have a very generous listening ear to making arrangements to bring that bill up to its current position, if there's been a lack of communication to understand how those payments were supposed to be made. If there's any indication that there's financial exploitation, then that needs to be investigated as well. And so that usually involves an investigation by both the long-term care Ombudsman program, who sometimes refer those cases to Adult Protective Services in the event that there would be an indication of somebody not paying the bill, but actually having access to the account and using it for other reasons. I will say that of all of the points that are here right now, the one that we do get the most cooperation from facilities on changing it and dropping the involuntary discharge is the resident's failure to pay. That is the one that we do get the most cooperation from facilities to make an arrangement to pay that bill. And then of course, the last point would be if the facility is closing. And in my area, we've had that happen twice in the last couple of years. So at that point, we want to make sure that even though there are actual steps involved for the facility to get all of the residents moved to another facility, our program gets involved and makes it an all hands on deck to get in there and make sure that each of the residents is going to a facility that will meet their needs. So that's important to know too. So a discharge notice must be in writing, and I mentioned that before, and it must include the specific needs. Maybe I missed my part. No, I thought I lost my space. The reason for the discharge. So as I mentioned the points before, and those are usually blocks on the first sheet of the involuntary discharge. So it's going to have that not being able to meet the needs, behaviors of the resident that may either endanger the safety or the health of other residents, and not willing to pay. The proposed effective date. So again, let's go back to the example of July 1st to August 1st. July 1st is the date that it is issued. The effective date of the 30-day notice is the August 1st. That's the date that they plan on moving you to another facility. The location to which you will be discharged, that must be included on that involuntary discharge. And there are many times when that part is not included. And in an appeal, that's something that you can argue if the facility is not willing to start all over and complete that section of the discharge. We as Ombudsman, if we are included in an appeal hearing for that, our purpose at that hearing is to make sure that the resident goes to a facility that is safe and meets their needs. So when the facility is issuing that involuntary discharge, and in the case, let's say, of we can't meet your needs, you need to move somewhere else, that this current facility is responsible for not only proving that they can't meet the needs of the resident, they are also responsible for showing how that the new facility, if they have it identified on the form, how that facility is better equipped to meet the needs of that particular resident. And if they fill in that part with to be determined and not yet assigned, there is no way to know that that resident is actually going to a facility that better meets their needs. And so you would want to, again, contact the local or the regional long-term care ombudsman program in your area, and other agencies to find out what you can do to help your loved one in the appeal of that involuntary discharge, or if you are actually looking for another place and choose not to appeal it. So a few tips. Well, here again, I don't know how to dance. The reason for the discharge, as I mentioned, I'm actually a visual learner, so I'm surprised that I was looking at a blank screen and not seeing that I didn't do this. The proposed effective date, the location where you will be discharged, the information on your right to appeal that is included, and it does have that appeal form at the bottom of page 3 or 4, and the contact information. It's supposed to include the contact information for the long-term care ombudsman program, but there's absolutely no place on that form that includes that, and many facilities do not write that in on their own. So also, notice should be given not just to the resident, it should also be given to your representative. So, and since that is sent certified mail, most of the time the representative is getting that notice up to 3 days, let's say, after it has been issued. So if you as a representative get that in the mail, by the time you get it, 3 days have also have shaved off from that 10-day window to get the appeal sent into the office to make sure that your appeal is actually filed. So most notices, again, are the 30-day advance. There are instances when there is one more immediate, but that involves with the grave danger to other residents. And the listed location must be specifically available and appropriate to the needs of that resident. So here are the few tips that we need to be aware of. Your doctor, if you're must document the reason for the discharge in your medical record. Now, I will admit that when I first saw this, I wasn't even aware that the doctor, so when I look at this, I interpret it as, is that my doctor or is that the facility doctor? And if it's the facility doctor, it should be in the medical record of the resident in the facility. So that's something to be aware of. If you are the resident or the resident's representative, you want to know if that's noted in their medical record. Also, if you are somebody who is on Medicaid or another third-party payment plan, if your Medicaid is pending, the facility can't discharge you for failure to pay because, as the phrase says, your Medicaid pending. So there's really no payments from Medicaid made until that Medicaid pending moves to actual Medicaid. This includes if your initial application to Medicaid was denied, because if it was denied, and that could be for a whole slew of reasons, simply not filling out the Medicaid application correctly, that's really easy to do. So you're going to appeal the decision because you realize you missed a page or you answered something incorrectly. So now you've filed an appeal. As you are correcting that initial application for Medicaid, additionally, they cannot discharge you from the facility because you need to have that appeal ruled on. So that's yet another reason why they cannot discharge you from the facility. And they're also responsible for notifying residents if there is a change in their payment status. So let's say that you actually are not on Medicaid, that you've been private pay because you've had the funds and you didn't qualify for Medicaid. So you're paying private pay, but your funds are running out. You should get notice from the facility that you are soon to be out of money to cover your private pay expenses, so that they should be starting the process for you to become Medicaid pending. So, and finally, the last point here is the facility must do some problem solving for the reason for the discharge. And that goes back to when I talked about how the most often that the facility does make an attempt to rectify the situation is in the case of failure to pay. If it is that miscommunication, then that's something that they're willing to come up with a plan to keep you current on a current with the current charges monthly, but then also a way for you to slowly, pay back what was due for the months that you weren't paying at all. If the notice says that the facility cannot meet your needs, and I brought this up before, they must be specific about what they can't do for you. So it must be documented in their medical record. And they have to document specifically what that facility has done to try to meet those needs. And then, of course, they have to make sure that they prove that the facility that they've identified as the facility they're moving you to is better equipped to meet your needs. This is, except for specialized facilities that have like specific psychiatric or bariatric or ventilator care, most nursing homes are certified to provide the same types of care and services. So they really need to hone in on why they selected a facility that they think better suits the needs. So you need to know your rights. And you need to be an advocate for yourself and we help empower you with that advocacy for yourself, but then we also help you as well. You have the right to appeal your discharge. So you make that point clear, and this facility must help you in completing that appeal sheet that's in the involuntary discharge paperwork. You have a right to remain at the facility where you're staying, right? Like I said, you've developed relationships, and look at this picture here. Felix is sitting in this resident's lap. She's at a facility that allows pets. Not all facilities allow pets, and perhaps the facility that the current facility has chosen to move you to doesn't allow pets either. So you have a right to stay where you're at, and that's why you have that appeal process and why that's in place for you. If you are at the let's say you've been in the hospital or you've had to go to some other location for some sort of therapeutic treatment or whatever, and now you're ready to come back to the facility, they have to allow you to come back to the facility from the hospital. Or if you had to go somewhere to go for some treatment and you had to leave, via car or plane or wherever to go wherever it is you needed for treatment, they have to allow you back. And so if they can't, they do need to make sure that they have a bed for you. Maybe they can't give you the exact bed that you had when you were at the facility, but they have to provide you another bed. And if there's changes in the eligibility of your services, and you have a different type of financial liability, you still have appeal rights, but you have to exercise those rights and knowing how your status has changed with both Medicare and Medicaid. And you might have to find another source of payment for that. So you have the right to know about the changes to your room and to your roommate in writing in advance as well. So if you're going back, when you're going back to the facility from being in the hospital. And if you do move to a new facility, you have the right to refuse transfer from one portion. Well, before you go to another facility, let's say you're at a facility that has assisted living and skilled care nursing. So they're saying, oh, you need too much help now. We're going to move you from assisted living to skilled care. And perhaps you're thinking that you're just fine. And once you're done with physical therapy, you can go right back to your apartment. Well, you have a right to appeal that moving from one part of the facility to another. You have a right to be heard as to whether or not you can go back to assisted living, and you can take care of yourself once you've completed the physical therapy and gotten yourself back on your own 2 feet.
Oh. Hey, Teresa, let me ask something while you're right there, because it's something I've heard a few times this year. If, let's say there's a husband and wife and one of the two needs to get moved to skilled, don't they have to work to keep their husband and wife together? And then how do they bill that?
Well, how they build it, I'm not, I guess, cerebrally equipped to answer that question or experienced enough to know that one. I would think that if both people are in assisted living, and anybody can correct me if I'm wrong, if you're in assisted living and let's say the wife goes to the hospital and has to have hip replacement surgery, and she comes back and she has to go to skilled care because she has to go through physical therapy to get herself strong enough to move, if her intentions are to move back into assisted living, I believe the husband stays in assisted living because she's only going to be in the other side of the facility on a temporary basis. And that's kind of the point I was making here. If you're talking about if the wife, let's say she had a different surgery where long-term wise, she's not going to get back on her feet. She's going to be, for the foreseeable future, she's going to be in long-term care that provides skilled care nursing round the clock with her on a long-term basis. That's the one that I believe the husband is allowed to move over there with her, but I don't know that entirely. I would actually probably rely on either Jessica or Kelly or Lee to answer that question for me.
Well, Carrie, I could just share with you, I'm hearing, can you guys hear me okay? Are you hearing a lot of repeat?
Nope.
Okay. So I would just share that I did hear of a continuing care community that had an individual go out to the hospital, a husband and wife. The husband went out to the hospital, came back, needed therapy. And so he moved into the skilled side of the nursing home. And this was through COVID as well. So the wife then opted to move into the skilled side temporarily with him, so that they could be together, and because of the quarantining, so that she could be with him and stay with him. Now, she did have to pay because she didn't have that reason to be in the skilled facility. So she did have to privately pay for that to occur. So it was an option that the facility, which I thought was a really amazing thing that they provided her with that option. And he did have to stay in the skilled side because of care needs. They were opting for him to stay because it was getting too hard for her. She realized being in the skilled side and having the nurses and the nurses' aides there to provide the assistance, that she would not be able to do this on her own if he moved back to the assisted living. So she did wind up moving back to the assisted living, and he stayed in the skilled. So it does become stuff with payment,
Right.
is where that can get a little sketchy, Carrie, I would say.
And I think that's because in skilled care, you've got more services available to you. Even though he's not using them, he's taking up a bed in the skilled care nursing part of the facility.
Okay, and that's what I was guessing. That's why I kind of, like I said, I've heard it once or twice this year, so I wanted to bring it up, and just in case.
Yeah, this is Jessica. I would just, encourage you to look at the contract or the policy for that specific facility too. There may be a regulation, I would have to dig, but it can get kind of fuzzy because you shouldn't be in skilled care if you don't need that level of service. And so it's just wading through, I really think most likely on a case-by-case basis and figuring out what's in the contract and is that facility set up to make allowances, because I think a lot of them are. This isn't like this never happens to anybody. So I would start there probably.
And I think it is case by case, because usually when you're at an assisted living facility, there is a contract that you're signing similar to, it's not similar to moving into skilled care. It's similar to moving into an apartment. There are definitely rules there regarding almost as, I won't say apartment living because it's not, but I mean, it's a whole set of different circumstances with assisted living than what you find in skilled care. And when he does go to that skilled care side, he is denying a bed to somebody who needs skilled care around the clock. So you have to remember that. If you do move to another facility, Well, first of all, the facility must inform you if there are any changes to eligibility coverage, which kind of goes to what we were talking about. What happens with your financial liability and your appeal rights? But you need to know that you exercise your rights, and to refuse that does not affect your eligibility for Medicaid and Medicare. I'm sorry if I jumbled up that quote there. The display on I don't know if the display on your screens looks the same, but mine's running off the screen, so I'm not seeing everything. So I'm ad-libbing on part of that went off the screen. My apologies. If you do move to another facility, if that's what happens, then you have the you have the right. And my apologies, half my screen is not on my screen, so I will leave that to you to interpret on the backside, that where you have the right to. And I don't know, I mean, my screen is slower than when I practice this, so I'll let you guys.
It's saying you have the right to know about change to your room and or roommates in writing.
Yes. Okay. Thank you very much, Carrie. I appreciate you handling that for me. If you do move to another facility, you have the right to participate in all parts of the discharge planning and arrive safely with all of your personal belongings. So you get to take all your stuff with you, your clothes, and perhaps if it was a place that lets you have pets, so you've got your cat there as well. The important thing is that what you need to know is that you have to know what's going on every step of the way. And there's nothing wrong with that. And if somebody's talking too fast or using words that you don't understand, whether accidentally or on purpose, just tell them that you're confused. Ask them that you want to understand everything that's happening. Since you have a right to be included in that discharge, you have a right to understand it. So please talk to me so that I understand what you're saying to me. That's really the most important part to remember from it. So here's the part where you take action. Here's the checklist that you want to keep in mind. So you're going to check the notice when you receive it. If you're a resident, you're looking at it. Make sure that everything's filled out correctly. If you're the representative, you also want to take notice on if it's filled out correctly. And you want to file the appeal before, again, this says before the discharge date. You want to file that appeal within 10 calendar days, not 10, or excuse me, 10, actual calendar days, not business days, 10 calendar days of receiving that, of when that involuntary discharge was issued to the resident. If it's issued on July 1st, you have until July 10th to file that appeal. That's what's important to remember about the appeal process. Ask to visit your new home. If they selected a facility for you and you've never heard of it, you don't know what it is, you tell them that you want to visit it. You should be allowed to visit that facility, because if you don't like it, you don't want to live there, you don't have to go there. Also, it's usually through the social services director. You ask for help to understand how this is affecting your Medicaid. How is this affecting my third-party payment plan? And file a complaint, especially if you felt that this came from out of left field. You don't know why that they're issuing this involuntary discharge to you. Maybe you suspect it's retaliation for something that you complained about, and now they're saying they can't meet your needs. So file a complaint, and you file that complaint with both the long-term care ombudsman program, and you can also file that complaint with the regulating agency, which is the Illinois Department of Public Health. And I believe that phone number and web link is also included in the chat stream of this presentation. And again, it says to contact your ombudsman, and we do supply that information as well. So how to get help? That's the next question. Well, you're going to look for us. You're going to find us, and here's a link here, which is also included in the chat stream. You don't have to deal with this all by yourself. You can always ask for help. So you find the long-term care ombudsman. Each state has a long-term care ombudsman program that has advocates that advocate for and with the residents to make sure that they have a quality of life and that they have quality of care. Those are two rights that they are allowed to have. And you contact our program if the facility staff is pressuring you to move. You ought to think about finding someplace else to live. No, you tell us that, and we make sure that that kind of intimidation goes away. You receive a discharge notice, you would contact us, or if you just want information, support, or to make a complaint about some other care, lack of quality of care and quality of life decisions that are going on in your facility. You can also file the complaint, like I said, with the Illinois Department of Public Health. And you would find that information in our chat stream, of course. The number for Illinois Department of Public Health is 1-800-252-4343. And you can also go to consumervoice.org/get-help, I believe. I think that those links are also in the chat stream, and there's an elder care locator. That's also an 800 number that is included in the chat stream as well. And there are other resources that we can provide you as well. And those are at the very end of this presentation. And they include locate and learn about the Long-Term Care Ombudsman program. A lot of that is also in the chat stream. And you can also find these other resources. You can find all this information is also in the chat stream. I'll leave this up for a moment in case somebody's wanting to actually write that down. Information for nursing home residents, you can find that. These are all through consumervoice.org. You can find information for nursing home residents. You can find the federal nursing home regulations on Consumer Voice as well. More information on involuntary transfers and discharges, also at the consumervoice.org. And returning to the nursing home after hospitalization or therapeutic leave. That's important to know because those are situations that sometimes come up as advantageous to administration at facilities, but not necessarily in the right mind for the rights of the resident. And that, the last thing I wanted to tell you about was that the National Long-Term Care Ombudsman Resource Center provides support, technical assistance, and training to all 53 state long-term care ombudsman programs and their statewide networks of almost 600 local programs. So that's the extent of that. I did want to add this on at the end. I did mention that, that I am the regional ombudsman in Central Illinois, 6-county area here. We operate out of the offices at the Center for Prevention of Abuse in Peoria, Illinois, where all of us pledged every day to provide confidential and compassionate services in a safe environment with one goal in mind, and that is to empower all people in our communities to live free from violence and abuse. And with that, I'll turn it over so that if anybody has questions, they can ask me, or as I alluded to before, the cerebral brand of our phone call here.
Well, can you guys hear me okay?
Yep.
Can everyone hear me okay? I don't see any questions so far in the chat, but there were a couple of things that came to my mind, Teresa, while you were sharing the information with us. And one of the things was for discharging, the reasons for discharging people. And one of that was the behavior, quote unquote, which I hate that word, behavior. I think we need to all change that word. I'm nothing against you, Teresa. I just said that's what facilities will say to you. We can't handle that behavior. That behavior is a threat to others who live here. And I do think that it's important that if that ever becomes any reason, what anyone says to you, is it the facility should be tasked with trying to understand why that person is behaving the way they behave. And the term that I like to use is, I don't like to believe that it's behavior. I believe it's more of an adverse reaction, that they're reacting to something. And because that reaction then is creating an adverse effect on the individual or towards other people. So it does become the facility's responsibility to explore that and research that. I think that's a very important thing for all of us to know as caregivers, as advocators, as people who live in the nursing homes, as people who love somebody who lives in a nursing home or assisted living or supportive living or any long-term care type of community. So you'll see that most behavior is a reaction. So encourage them that they should be tasked with exploring that, what that is.
Right, and I think a lot of it, or thinking about it as being, you know, I always think of it as pushing buttons. It's a stressor. It is a reactionary stressor that it brings about behavior. So I always get backed into a corner when I'm trying to work around the word behavior. And it really takes me right back there where I can only get out by using that. So I have to come up with some other words.
So let me give everyone a real life example because this happened to us. So we were very close to my son getting a involuntary discharge. And you've all heard me say how much I love the facility he's in. So right at about 2 years ago, probably 7 months before COVID had started, we had tried a brand new medicine that had just came on the market. It was supposed to be our miracle cure for seizures with 0 side effects. Ha ha. And my son had astronomical side effects. He started hallucinating. He started having rages. We had all these things that weren't adding up. And the facility, myself, everybody, we didn't realize at first this was the medicine. So, you know, we had had meetings, they had changed roommates, they had done all these things. They'd given us warnings that this could happen. So where Lee said, if they're, especially using that word behavior, start investigating, have your meds changed. What has set that off? You know, because my brain at that point was still under, oh, everybody says this medicine has no side effect. So, and what it was, there's one form of CBD oil that actually is FDA approved, only for seizures. And literally we went on it as soon as it came to market because we were supposed to go in the trial and then the trial didn't happen in St. Louis. So it was a very eye-opening experience.
And I find that when we use that word adverse reaction, Carrie, what you're talking about is your son had an adverse reaction to a
Correct.
medication. And so nurses typically respond well to that terminology of adverse reaction, because if somebody was taking a medication and they all of a sudden started breaking out in a rash, that typically gets referred to as an adverse reaction. So then they explore, well, what else could we do besides give them that pill, that medication? Is there something else that we can do for them? So it becomes very a proactive situation. So when you start using that terminology, adverse reaction, it starts to put the ball in a different court. It's not the person owning behavior, it's others owning what are they reacting to. So I do find that that can really start bringing people into that caregiving loop a little bit better, so that they want to help problem solve it as opposed to blame. Behavior can become a very blaming word. We teach children you shouldn't behave like that and you need to control your behavior. We do that when it comes to behavior. But when we start talking about reaction, it's more about what happened to me that I responded in this way. So I think it can be very helpful to change our terminology if that happens, because that is one reason why many facilities do want people to, they will start initiating an involuntary discharge. They cannot handle that person that has a dementia reaction, and they're reacting to the loud noise that happens every day at 3 o'clock during change of shift. And the person gets very aggressive and shouts out, and it gets very difficult to deal with that person. But if we changed things at 3 o'clock, would it look different for that person? And would they not react? That behavior disappears.
Agreed.
So I think
Yeah, I kind of coming off of that, Lee, I had a resident 2 or 3 years ago who was he had dementia, he was in his 90s, and he was making sexualized comments towards the staff, and at times even like trying to reach out and grab them. Now, I went in and talked to him, and as far as he was concerned, he had just moved in that morning. He'd lived there for a while, but he thought he had just moved in. So there wasn't really any working directly with him. And so what I had to do was try and brainstorm other ways that the staff could interact with him. And that solved the situation. So rather than the staff coming in and just starting to work with him, they come in and they start the conversation. So it's a conversation that's on their terms about appropriate things like the weather or sports or whatever he's watching on the TV. And so he doesn't have to come up with whatever sexualized comment he wants to make that day. And just that right there helped him, and it helped the staff mostly, but it helped it helped the resident stay in his home.
But you were very accurate, because some of those issues we were having, and it got to be that, okay, until we resolved the issue, female staff weren't allowed to go in with my son alone. They tried to do a female and a male always, and if not, at least 2 females, until we figured out what was causing those issues.
Yeah.
So
And this could be
My
a whole
experience-
amazing conversation, really, to talk about. And I like to use that Maslow's hierarchy of needs, if anybody knows what that's all about. But that initial is about having your basic human needs met, and sexual activity is a basic human need.
Yeah.
So if you don't get that, and many times it's just that need for love and belonging. That's what that can be. And if you don't have that met, how do I feel loved? How do I feel belonging? It can come out in an inappropriate way of doing that. So then we have to take a look. Can I find other conversations that can make that person feel comfortable, feel a part of something, be able to have that feeling that people care for them as an individual? And just that replacement can change that stuff.
Yeah, and I think that especially now, especially as the restrictions for COVID are coming up, it's kind of like a tide that came in. The tide of COVID came in with the restrictions and the quarantines, and now the tide is leaving, and you're thinking, oh, everything's better. No, when the tide leaves, that's when you see all the junk. And right now, a lot of other things are coming up, and the only time I'm seeing those excuses of endangering other residents or being unsafe for other residents, those 2 excuses are being used on emergency involuntary discharges, where by the time we get that paperwork sent to us, that resident's already out, and they're usually law enforcement has come to get them. So
Yeah. And I do think that other thing to talk about is what you talked about that hospitalization as well, Teresa. That when you go out to the hospital, you have the right to come back to your home.
yeah,
They can't switch that home on you and
Right.
force you to go to another place. And I think that because we do see a lot of that, we will see where a facility, and they'll refer to it in the industry. I don't know if many of you have heard this term, but that hospital dumping. Let's get that person. We're going to discharge. We're going to figure out how we can get them out. We'll get them out to the hospital. And then from there, we're not going to allow them to come back to our facility. I don't know if any of you guys want to speak to that.
well, I've had many situations, and it's usually repeat offenders when it comes to facilities, where they do send somebody to the hospital, and then they do try to issue an involuntary discharge while they're at the hospital. And sometimes they don't even do that. They just say, no, we're not taking them back. So we go into this conversation over and over again, where it's like around the circle, and I'll tell them, I'll say, if you're not taking them back, that's hospital dumping. I need to report that. Well, no, don't report it, because we're not hospital dumping. Okay, so then you're taking them back. Well, no, we're not taking them back. And then I say it's hospital dumping. And I usually leave them with the option. I'm going to make a phone call when we hang up. It's either going to be to IDPH, or it's going to be to the resident, telling them that they misunderstood and they get to come home. And, I've been lucky enough that every time I've gotten to that point, when I have to get to that 4th time around the roundabout, they do take the resident back. But I mean, it's to the point where I almost have to go and stand at the front door to make sure they get back, because then I'll get calls from the hospital saying they're not. They might telling you they're taking them back, but they're telling us no. So, I've gotten to where I've had to go and stand at the door when they say they're coming back.
And many times the reasons why they say it will be one of those reasons that is a reason for discharge, which would be because of the behavior or because of the care needs. We
Yes.
can't care for this. They have too many care needs now. We can no longer care for them. And that has to be explored. Why specifically are you saying that you can't do it now? And unless, like Teresa explained, if all of a sudden they are, they need to go out every day because they're on dialysis, and they're not a building that can do that, that would then be a legitimate reason. But other than that, it's not just because, well, they have a pressure sore now, we can't handle the pressure sore.
Right.
Or because a nursing home should be able to handle those things.
Yes.
So don't just take this is where it becomes this right piece. That's why we're talking about this, is we've heard these things happening through COVID. We
Yeah.
have heard this stuff happening, and it's your right to be able to live in the home that you want to live in.
Exactly.
Yeah. We did not get a lot of questions today, but we did have another topic we were going to talk about, and we're not going to do it in 3 minutes. And we knew that this is potentially something that could happen with these conversations that we're having. So we can take that conversation and we'll put it, we were going to be talking about your financial rights. And we were doing that in light of also the stimulus checks that people were receiving and making sure that people were not allowing it to become an asset for them. We will have this conversation. We will make that, if it's not our next topic, it will be the topic after that, because this is another very important topic that we've got a lot of questions from, and we want to make sure that we are honoring this group. And the reason for all of this is information is power, right? That's what this is about today. Dynamite information that gave us a lot of ability to be able to be empowered, so that we don't have to feel that just because somebody says I can't live here anymore, that I have to swallow hard and take.
Right. Well said.
And so next time we had tentatively arranged for the topic of, it's June. So now what, what should we be seeing? You can see my cat in the background. So if I ever moved into, she decided to join us today. I don't know if you can see my cat back there. She decided to join us today. But if you, the initial conversation was going to be, we were inviting public health back, Dr. Kennard, who we had on several weeks ago, I believe at the beginning of May, end of March, to share with us. It was March, okay. To share with us what we asked questions, and she shared with us what we should be seeing and gave us that opportunity to be able to make sure that she heard what was actually happening. So we were inviting her back for another conversation, because things have changed a lot since March, and it's continuing to change every day. And hopefully it's continuing for the positive, so that everyone here can get to see their loved ones as they want to see their loved ones. So we were going to have that invitation extended. We have extended that invitation, but that has not been, we have not been able to further that conversation right now. So we will be either talking along those regards, and or we'll have an open conversation about what are you seeing, so that we could get a better handle on what we need to be also doing as ombudsman, and are there things that we are not hearing singularly. This opportunity gets to hear, for us to hear it collectively. So either that, or we may be bringing the financial conversation back into play for our next meeting. I do want to remind everybody that this is your meeting. These topics are organically happening through conversation with all of you, and what our regional ombudsmen are seeing when they're out in the field. So please help us to come up with these topics. If anybody would like to join the work group, we have a work group that decides on the topics, who's going to talk about it, what information needs to be included in it. Please feel free to email me. I'll go ahead and I will type my email address in here, but it always comes with the invitations as well. And it's very simple. It's just my first name and my last name. My first name with a dot, my last name, which can be a little complicated for some people if you're not Irish, and at illinois.gov.
Hey, Lee.
Yes.
So I was not the only person this afternoon who was like, oh no, I have no link. So why don't you explain to everybody what you texted me and told me? Because then life becomes much easier.
Well, Carrie, it does become, so just to explain to everybody, we are, as you can see, the Illinois Pioneer Coalition is helping us sponsor this event through their Zoom account. We are limited in the numbers of people because of the type of Zoom account that they have set up. That's why everyone at this point is registering, so we can see the numbers of people that are registering. We can get people that register, and unfortunately things happen and not everybody can make it. So it is always the same registration link. So if for any reason it always is the same Zoom link, but we still are asking for you to register so that we could track the numbers, so that we don't go over that, so that somebody who really needed to be here and wanted to hear it is then not allowed to get in because they registered and the rest of us might have just kind of snuck in because we knew that account already existed. So if you ever do have a hard time coming in, you can go ahead and click on the link for today's meeting or for a previous meeting, because we've set it up now that it is the same link. But I still want to encourage you to go ahead and go through the registration process just so that we can track that number so that we don't wind up bouncing people out that registered. And Carrie, it looks like you're doing a nice little gardening project over there.
I very seldom do one thing at a time. Very seldom.
I love it. I love it.
Um,
Does anyone
ahead.
have anything else that they would like to comment on? Okay. So with that, I'll go ahead and I will end our recording and I will stay on. I'm going to let you know that all the links will be placed onto our IDPH website. If you go to the Illinois Pioneer Coalition, the Illinois Department of Aging's website, and you click on the Ombudsman link on that homepage, then you'll see on the right-hand side, there is a Resident and Family Support Council is a link there. You can click on that and that will bring you to all the resources that are shared as well as the PowerPoints. And we're still trying to work on getting these Zoom. It does take up a lot of memory. And that's where we're running into some issues, is getting the video recordings placed up there. We haven't given up hope, but we're still trying.
Hey, Lee, call me about that. I